The claim that if you search for something illegal, the police will come at your door in 10 minutes is simply false. It's really an outlandish claim. So one of the really strong sort of legal doctrines in the United States is the doctrine of what's known as prior restraint. And prior restraint is seen as a bad thing. Prior restraint is censorship, right? We need to go to get permission from the government to say something. Once the cat is out of the bag, so to speak, once whatever information has escaped the government and is out there, right, then it's fair game to publish it, especially if it's a public interest, right? There's no question about that. So there's no criminal defamation in the United States. You cannot be jailed defaming somebody. Civil liability. Pakistan has a strong constitutional provision that protects the freedom of expression, and that is a signatory to important international human rights treaties that have very similar protections, right, for free expression.
Hello and welcome to this episode of the Digi Pod. Today I have with me Vivek Krishnamurthy, who is a professor at University of Colorado. Vivek, thank you so much for joining DawnNews English today. We're discussing content regulation. Since the beginning of this year, a lot of wild claims have been made about how it works in other jurisdictions, a lot to justify what has been happening in Pakistan, whether it's about a firewall or PTA's practices with respect to content takedown. Vivek, let me throw one such claim that was recently we read about in the papers, which was that if somebody searches illegal content in the United States, there will be a knock at their door in 10 minutes. Could you unpack this and actually tell us how does content takedown or regulation actually work in the US?
Sure. So first of all, let me just say what a pleasure it is to be here with you today. Yes, the claim that if you search for something illegal, the police will come at your door in 10 minutes is simply false. It's really an outlandish claim. So let's use that claim to unpack how content regulation happens in the United States. So first of all, in the US, the sort of set of content that is regulated is quite narrow because of the very strong constitutional protection for free expression in this country. That's consistent with lots of other democratic societies. The US system is a bit different than most in that it's a very old system. So we have the First Amendment, which is the free expression protection in the United States. So under that, the government has a very heavy burden to bear if it wants to restrict content, right? So in terms of the substance of the law, there are lots of cases, and we can get into the details of what's illegal, but basically, extreme obscenity is illegal in the United States. Content that is going to incite imminent lawless action, right? So that's a very high standard, is illegal. And then there's, of course, protections for intellectual property, for reputation, defamation, privacy, and the like. Okay, so that's sort of the substance of what can be regulated. But then there's the how. So the statement presumes that there's some kind of vast monitoring system where the police can say, aha, 10 minutes later, I know that this person did something naughty and we're going to go to their door. That's absurd. There is no such system. There's no general obligation in the United States to monitor what happens. So if you're unhappy about some content that's online, first of all, if you want to want it to be taken down, you are going to, so there's a difference between sort of takedown and then criminal responsibility, right? So on the takedown side, you need to get a court order, more or less, right? If you're a private litigant and you're unhappy, you go to court. And then the court actually can't generally order an intermediary to take it down. It's the person who posted it who has to take it down with regard to defamatory content, privacy breaches, and things like that. Now, there's sort of an exception for copyright, which is it's a self-help system. So if you are the owner of a copyright and you see something online that you think violates your copyright, well, you go to the platform hosting it and say, hey, I think this is my copyrighted work. I want you to take this down. And the platform does that and then informs the person who posted it that they've done so. And then the poster gets a chance to rebut that allegation. So anyway, again, the point is that there's a strong degree of legal process here. There is no monitoring system that could lead to anyone coming to your house within 10 minutes, right? And most of the mechanisms are private, right? So people who are aggrieved go and resolve their own disputes, right? And we can sort of talk about some of the exceptions to that if we want to, but I mean, just the notion is fundamentally flawed and frankly absurd on its face.
So primarily, this is private complaints or private individuals, and it's not in the domain of the state or the government. When you contrast to Pakistan, and especially the way the regulator has been empowered through Section 37 of the Prevention of Electronic Crimes Act, and then again, we see that a lot of this is not public facing. There isn't a transparent model. They decide whatever it is that the exceptions are. Now, contrasting that, even if, let's say, the state had any, one, does the state have any interest, or are there government claims with respect to national security or content takedown? And if yes, how does that work differently? Or what is the threshold that they're required to qualify, if at all, that this process works over there?
So there are some really interesting cases that involve precisely these questions in the United States. Most of them predate the internet, but they have sort of set the landscape of how this works in the US. So one of the really strong sort of legal doctrines in the United States is the doctrine of what's known as prior restraint. And prior restraint is seen as a bad thing. Prior restraint is censorship, right? We need to go to get permission from the government to say something. So the way this has been sort of interpreted is that the free expression protections are extremely significant, right? So to stop someone from saying something is pretty anathema to the American tradition of regulation. Now, there might be consequences for saying something, but even those, the sort of ambit of public interest is pretty large. So let's take a great case, which is what's called the Pentagon Papers case. So in the 1970s, during the Vietnam War, somebody leaked top secret documents, right, to the New York Times and to the Washington Post and other journalistic organizations about the U.S. war plans in Vietnam. Government didn't like that. The government tried to stop the publication, and they failed. The court ruled that you can't do that, right? The First Amendment protects the publication of these things. Once the press has it, even if it's a risk to national security, you can publish it unless it is extraordinarily dangerous and imminent, right? So if you're going to imperil somebody's life in that moment, minute to minute, then maybe the government can can pause it, right? They can't stop it, but they could delay it for a little bit. So the example is there's a ship at sea, and if you had the information, the publication of the information would let the enemy sink it. Well, then maybe we'll hold it off for a day or two, but you can still publish it. Now, the person who leaked it might be in trouble. They might be subject to prosecution. And we've seen this happen, for example, with Chelsea Manning and Julian Assange, right? People who leaked U.S. secrets. You can be, if you're the leaker, perhaps then there's some criminal liability there. But the actual publication is extremely hard to restrain or to attach liability to that, right? So that's military secrets. Then there's sort of the question of government criticism, right? You know, can you defame the state, or like anti-state propaganda be a charge? And absolutely not, right? And we can go into these cases. There's some wonderful cases with people using very colorful language to criticize the government, to criticize the military, and the courts have ruled time and again that that is protected expression. That in fact, vigorous criticism of public institutions is part and parcel of a democracy, right? And that's how we hold governments accountable, is sometimes with very strong words.
So that's another thing that's happening in the Pakistani context. We're seeing prosecutions, renewed prosecutions again, and the discourse, the narrative that this and blanket umbrella terms such as anti-state content, and like you're saying that these have been protected. It might be offensive, but not necessarily illegal, or shouldn't be taken down. What is the distinction between, like you already mentioned, the criminal prosecution part and then the takedown part? They run as two separate streams, it would appear. And so, which, if I understand correctly, is that while a whistleblower, let's say, could be prosecuted and has been prosecuted, and that's something that has been critiqued as well, those publishing don't incur the same kind of liability as the person who brought to surface those documents or revelations?
That's correct. So once the cat is out of the bag, so to speak, once whatever information has escaped the government and is out there, right, then it's fair game to publish it, especially if it's a public interest, right? There's no question about that. That's very well settled law. As to the legal status of whistleblowers and leakers, that's a little bit more complicated, right? And in fact, in this country, I think we have seen some attempt to use sort of a secrets legislation, right, or anti-espionage legislation to go pretty aggressively after people who have blown the whistle on things that are very much a public concern. And, this is sort of what governments often do. They don't like it when their secrets are leaked. But the judiciary has been pretty strong, right, in protecting the absolute right or near absolute right of the press, of media organizations to publish things once they are out there, right, and to engage in extraordinarily vigorous criticism of public figures, of government policies, you name it.
So just because somebody says something about a military official or military plans, or even a government official, that is one not liable to criminal prosecution or even takedown. Is that correct? And how the courts have interpreted it?
That is absolutely correct. So there's no criminal defamation in the United States. You cannot be jailed defaming somebody. Civil liability. Now, if I were to defame just, a colleague of mine, someone who's not well known, a private person, there's one legal standard, right? It has to be false, and I have to injure the reputation. But the Supreme Court, in this very famous case called New York Times versus Sullivan from the 1960s, ruled that, you know what? If you're a public official, there's a higher standard that you need to show. It's not just the injury and the falsity. You have to show actual malice, right? That you had an actual intent to maliciously harm that person, right? The idea being that if you are a government official, military official, or you're involved in public life, you're an actor, a singer, whatever, you have to have a thick skin, right? You've put yourself out in public into the public sphere, and people have a right to say things about you, right? And that can be pretty extreme, right? So, for example, there's another case, involving, again, the Vietnam War was a great font of these cases, right? Where someone said, if I get drafted, I'm going to, first person I'm going to shoot with my gun is the president. That was fine, right? It wasn't it was seen as hyperbolic statement. The person had no intention of carrying it out, right? That sort of thing is totally fine, right? People in public debate here say lots of terrible things about public officials, right? And the idea is that there's a wide latitude for commenting on things of public concern, right? So unless you maliciously set out on a campaign of character assassination, there's going to be no civil liability against you. And in fact, we have laws here that if you're even sued for defamation, and the idea is that, the lawsuit is a way to try to silence you, you can quickly get that dismissed with what's called an anti-slap, right? Which means that not only do you get that lawsuit dismissed, you usually get damages against the person who brought it against you, because it's seen as a way of trying to chill your speech. So yeah, these are very strong protections in the U.S. and quite dissimilar to what I understand is happening in Pakistan.
Absolutely. I mean, we see criminal prosecutions all the time. And also the other thing that's used, and this also came up in what you were saying, is the notion of false information, or the way colloquially the phrase is used, fake news or disinformation. And now there are more amendments to the cybercrime law that are underway that seek to criminalize the spreading of false information, although it is already happening. And again, false information about state institutions or state officials. How do you see, not in the US, but you've also looked at other jurisdictions and just how disinformation is dealt with? Is criminal prosecution the standard, the way that you deal with it, or are there other methods that are more proportionate in dealing with disinformation?
Yeah, I mean, certainly in established consolidated democracies, the idea of criminal prosecutions against disinformation uh, is really sort of beyond the pale. Um, so, one of the big problems, and people bemoan, and it's a problem, right? That there's disinformation, there's misinformation, right? The information sphere is polluted, right? For lots of reasons. But a major problem is determining whether something is true or false, right? Um, and whether you're saying if it's something that's false, are you saying it with the intent to mislead, or is it, are you being satirical, right? And satire is a big part in comedy, or obviously big parts of political discourse, right? People will say things to get a laugh, right, or to sort of, sarcastically, right? So you've got to judge the intent. And then, criminal prosecutions take a long time, and at least in countries with strong rule of law, right? There's a presumption of innocence and evidentiary matters, et cetera. So it's not seen. First of all, there's just the problem of determining truth and falsity. Second, there's the evidentiary burden. Third, there's the time horizon. Fourth, I think the commitment in most democracies is to robust expression. So the strategy is not to go and criminally prosecute people. It's to engage in counter speech, right? To say, that's ridiculous. That's absurd. Here's why. And to convince people, right? And to sort of appeal to the better angels of their nature as a solution to the problem. And of course, it's a real problem, right? But the use of criminal law, I think, is a pretty authoritarian and repressive device, right? It just attracts the possibility of people saying, sort of arguing that this is the version of the truth and the only version of the truth that should be allowed, when reality is often quite complex.
Finally, Vivek, I just want to round up the conversation on what we spoke about earlier. And there's also this common myth about the US or the First Amendment that there is free speech absolutism. And so everything goes, and, there is no way of where there is harmful content or harmful speech, no way to address that. If you could just, as we round up this conversation, just tell our audience that where there are exceptions, if those exist, but what is the process by which those may be applied? And it's not just is it just in the hands of the super regulator as we typically experience in Pakistan, or is there a process through which any of this has to go through?
So it's not true to say that you can do and say anything you want here with no consequence ever. There are limits, right? But there's two different ways that the limits are applied. First, in our system in the United States, we rely a lot more on the private sector, right, to self-govern different platforms for expression. So, for example, on any major platform based in the US, whether it's operated by Meta or Google or whoever else, everything that's legal, you can't say that, right? So, for example, platforms don't allow sexual content, right? Or they take their own stance against racial discrimination or whatever else that's harmful, right? That they judge harmful. So there's more of an emphasis on private ordering. But in the public sector, yeah, a lot of things can be quite harmful, right? From things that are fraudulent, that are meant to deceive people and get them to part with their money, to content that harms minors, right? The sexual exploitation of children is a big problem. Intellectual property is a problem. What's called non-consensual intimate imagery is a problem. And even within the sort of First Amendment protections, right, something that's legal in one context may not be in another, right? So what you can print in a book is different from what you might be able to say on the radio when children are listening, right? So the sort of regime of what's permissible depends on the context, right? So that's one big part of it. So contextual understanding. Second, I think a strong commitment to procedure, right? So if a government is going to regulate a kind of expression, and they're making a distinction based on what you're saying rather than where and when you're saying it, they have to show really compelling reasons that they should restrict, something on the basis of content, right? Is different to say that you can't play loud music between midnight and 5 a.m. because people are sleeping, to say that you cannot insult the government between midnight and 5 a.m. or insult the government at all. One is based on content, the other is not, right? So then you have to show that high level, right? And then the third thing is that before restrictions happen or penalties are imposed, there's legal procedure, right? A lawsuit is brought and it's litigated to the end, and the person who brings the lawsuit has the burden to show that the content is unlawful or harmful or whatever else. And same thing when there's a criminal prosecution for something like the distribution of obscene materials, right? You've got to prove beyond a reasonable doubt that the person did the crime, and that's a high standard, right? So I think those are sort of three different ways in which the American system, which does restrict expression in certain circumstances, has really strong substantive and procedural safeguards to prevent the arbitrary exercise of government power.
Anything else that you would like to add with respect to content regulation or best practices? Because you're also familiar with how this is playing out in the Pakistani context and the contrasting standards that you see, or the lack of standards that you see are applied.
So I'm by no means an expert in Pakistani law. I do note with great concern what's happening. But I will also note that Pakistan has a strong constitutional provision that protects the freedom of expression, and that it is a signatory to important international human rights treaties that have very similar protections, right, for free expression. And in fact, the Supreme Court has developed a very strong jurisprudence around free expression over the years that recognizes the importance of the right to free expression in a democracy, of holding the powerful to account, of engaging in robust political debate, right? And I think the judiciary has been very brave for many years, right, in standing up to overreach by the government. So I think what's happening is concerning. Certainly, regulators are amassing a great deal of discretionary power, right, to both set the legal standard for what they think is permissible and not, and then to go and enforce it. And that's inconsistent with Pakistan's best legal traditions, as I understand them, and with its international obligations under human rights treaties. I would, implore the government to live up to its own commitments. And I'm very impressed by the bravery of many people in Pakistan who, despite this rather repressive regime, are willing to stand up and hold the powerful to account and speak out on behalf of their rights, protected by both domestic and international law.
Thanks, Vivek, for joining DawnNews English. This is all we have for the Digi Pod today. As you heard Vivek say, that what we hear in discourse, whether it's by government officials or others who say this happens everywhere, it's not entirely true. There are substantive procedural checks that have been explained in this podcast. There are also tests that the government is subjected to when they seek to restrict a right. And while practically the constitutional rights that are available to us are not enforced to that degree, or the international commitments that we are signatory to, we don't see those in practice. But the fact is that they do exist and they do need to be emphasized. And there has to be a process, and there has to be qualifying of a particular need or a restriction. That's all that we have for today. Thank you.